Information Law, General Part. This summary is based on the works of Professor Vihar Kiskanam. We will approach this topic in 3 distinct parts. First, we will examine the correlation between information law and other branches of law. Second, we will look into the sources of information law. And finally, we will discuss the current status of Bulgarian legislation in this area. So let's begin with our first point, the correlation of information law with other legal branches and sciences. It is absolutely crucial to understand that information law isn't an isolated field. Rather, it is deeply woven into the very fabric of the entire legal ecosystem. You'll find that information law has 3 key relationships. It draws its fundamental principles from the general theory of law, it borrows its methods from a field called legal informatics, and most importantly, it has a profound impact on all sectoral legal sciences by defining how they operate in this new virtual environment. So what exactly is legal informatics? Well, you can think of it as the science dedicated to organizing, processing, and using legal information. It's focused on finding the common qualities and structures within legal matter. Information law then takes these organizational principles and uses them to build a coherent legal framework for our digital world. This quote really gets to the heart of the matter. Information law isn't just about adding a few new regulations. No, it's a much more fundamental force. It explores and actually creates new concepts for this new digital environment. It redefines what it means to express one's will legally, and that, in turn, affects every single branch of law. And just think about the kind of new phenomena this virtual environment presents. We're talking about things like electronic statements, or even automatic electronic declarations of will, where a computer system makes a legally binding decision. We have to consider electronic documents, certified email, and even something like a domain name. These are all legal realities that simply did not exist in the traditional legal framework. All right, that brings us to our second major topic. Now that we understand what information law does, the next logical question is, where does it come from? We're going to trace the sources of information law to understand the origins of its authority. The sources of authority here are distinctly multi-layered, forming a clear hierarchy. At the very top, you have international law, things like conventions on cybercrime and data protection. Then you have the European Union level, which, as we'll see, is becoming incredibly dominant. And finally, at the base, you have national law, constitutions, specific laws, and court decisions, which must all align with these higher sources. And you can really see the importance of that EU layer when you look at this timeline. There has been a remarkable wave of regulation. Starting with the EIDAS regulation in 2014, we've seen a cascade of major legislative acts: GDPR, the Digital Markets and Services Acts, the Data Act, and now the Artificial Intelligence Act. The EU is very deliberately constructing a comprehensive legal framework for the digital age. Now, in addition to those powerful regulations, we also have key EU directives. These have been shaping the digital space for quite some time. It's important to remember the difference. A regulation is a single law that applies everywhere directly. A directive, on the other hand, sets a binding goal that each member state must then achieve by passing its own national laws, affecting everything from e-commerce to public data. And that brings us logically to our third and final section, the status of Bulgarian legislation. This is where we'll see a real-world example of how this powerful EU-level regulation directly impacts a national legal system. What we're witnessing is a fundamental trend, a shift in the center of legal gravity. As the European Union creates more comprehensive regulations that are directly applicable across the entire single market, essential parts of national information laws in countries like Bulgaria are simply repealed. They become unnecessary as the regulation becomes more direct and binding from the EU level. So, if there is one single dominant trend to take away from this, it is this: the shift away from national legislation and toward direct EU regulation. This is the key dynamic shaping the field today. So, given this reality, what are the necessary future developments for a country like Bulgaria? Well, the path forward involves several key steps. First, establishing a new, unified legal framework designed for the virtual environment. Second, developing the core institutions for this new environment, like the e-document, the e-signature, and e-statements. And third, advancing the implementation of e-government and e-justice. Let's recap the key takeaways. First, remember that information law is not a silo. It is a foundational layer that influences all other branches of law. Second, Its authority is multi-layered, cascading from the international level down to the national level, with the EU playing an increasingly central role. And finally, this entire field is in a state of constant evolution, driven very heavily by comprehensive EU regulation. This all leads us to a rather profound final question. As our reality becomes more and more virtual, and as the law governing it becomes more unified at a supranational level, how will the very concept of law itself be redefined? Thank you for joining this explainer. I hope this has provided a clear overview of the general principles of information law.